Well, it's just gone over 6:30, as a matter of fact, 6:37, and it's here on Classic 102.7, and that means time for tonight's Classic panel. Amendments to the Labour Relations Act will see the introduction of the Code of Good Practice on Collective Bargaining, as well as industrial action and picketing. Stakeholders were told at the Department of Labour briefing session in Polokwane in November 2017. Thembinkosi Mkalipi, Chief Director responsible for collective bargaining, said the amendments are designed to strengthen collective bargaining, enhance labour market stability and promote proactive and speedy dispute resolution. He said the amendments come from a process of engagement through NETLAC on the state of labour relations environment, in particular to address violent and protracted strikes. In the spirit of Ramaphoria reform, is it not time to reconsider the elective bargaining framework altogether? I'm now joined by three guests this evening. The first person joining us on the line is Thembinkosi Mkalipi, the Chief Director of Labour Relations in the Department of Labour. Johan, who heads up Baker Mackenzie's Employment Practice Group in Johannesburg, and then also Papenfus, the Chief Executive of the National Employers Association of South Africa. Welcome to everybody. Thembinkosi, we're going to come to you online just now, but let's maybe start just with our guest in studio here this evening. Let's get everybody's opinion about the proposed legislative changes. Can this change the state of labour relations in South Africa? Johan, should we maybe start with you?
Thank you very much, Cobie. I'm personally buoyed and very optimistic about the proposed changes. I think it's a step in the right direction. Certainly, our collective bargaining process, if we look at the outcome of that and where things go wrong, we are probably the undisputed world champions in industrial action. This is not where we want to be. We have a happy workforce that's productive, that contributes, that attracts investment so that we can create more jobs and get more people into jobs. I take a lot of comfort from some of the amendments. I know Gerard here has views on some of the amendments that are, that is not as positive on it. But I think by and large, we are heading in the right direction. It's positive for us to actually recognize that there's something that needs to be fixed. And I think a number of those amendments, should they be pushed through, will actually assist us in remedying what is fundamentally wrong with our collective bargaining and industrial action process.
All right, Gerard, let's come to you, and then we're going to go to Thembinkosi to hear his opinion. You think this is a step in the right direction?
Well, in certain respects, it is. If you look at the measures that's introduced to curb violent strikes, of course, we're in favor of that, and there are many other things. But there's a particular proposal which we do not agree with, and that is on collective bargaining and the extensions of agreement. And it is because of NIASA's successes and the growth of NIASA and the growth of small business where we've come to the position where we can actually prevent the extension of agreements. And what the Minister has done, she's built in provisions that will give her the powers to extend agreements without agreement in the council. In other words, only one party can ask for the agreement. So what the Minister wants to do is to protect the collective bargaining or the extension of agreements without collective bargaining. Now that's wrong, and I think it's also unconstitutional, and I hope this particular provision will fall along the wayside. But this is definitely wrong, and it's a step backward. I think what should have happened is that the Minister should have made it easier for business to grow, to give loosen the hands of business. What's happened here is none of that's happened, and they in fact went a few steps backward.
Well, Gerard, it's good news that we've actually got Thembinkosi on the line. Thembinkosi, you represent government, obviously. Let's get your opinion. Is this a step in the right direction for labour relations in South Africa?
There's no doubt about that. This is a step in the right direction. Is dealing with many of the issues that are bedeviling our labour market. The codes of good practice that we want to publish are intended to change attitudes and behaviour of participants in the labour market. And the issue around the secret ballot before a strike is intended to make sure that if a strike does take place, it is supported by the majority of workers, and therefore reduce the possibility of violence, because our experience is that when strikes are not supported by the majority, they are more tend to be violent. Now, on this issue that Gert is raising about collective bargaining, I think he's making a mistake. Because if I know Gert understand the law, in the law is clear. Section 30 of the LRA requires that each bargaining council in its constitution, the constitution of the bargaining council must indicate the manner in which decisions are to be made by that bargaining council. Now, if a bargaining council in its constitution says a decision in the bargaining council, an agreement, is a decision taken in this manner, let us say if the bargaining council says it must be 50-50 employers and employees, or it must both parties, that's the decision making in the council. Therefore, nothing can go to the minister unless it meets the requirement of the constitution of the bargaining council itself. And Section 30 insists that bargaining council must have in their constitution the manner decisions are going to be made. Now, if a decision is made in terms of the constitution of the bargaining council, and that decision is then sent to the minister in terms of Section 32 that we're proposing then can extend that decision of the council. The minister can't extend anything but the decision of the council that the council has presented to the minister. And the minister, in determining the representativity, can then say if any of the parties are representative. I think that Gerard must look at the LRA completely in order to make a view on the issue. And as I'm saying, Section 8 is clear in terms of what's the requirement in terms of bargaining council constitution.
Well, I'm going to give Johan an opportunity now, but let's maybe Gerard, let's just come back to you. Let's just give you a right of reply to what Thembinkosi is saying. So let me just put it into layman's terms, because I mean there's a lot of you guys obviously come from a legal perspective. What we're basically saying here is that within the confines of a bargaining council, what you're saying, Gerard, is that only one party has to agree to a change in how this bargaining council operates, and what you're saying is that both should operate. What Thembinkosi is saying is that actually a lot of this actually is at the constitutional level within the actual bargaining council and their actual rules.
Well, Thembinkosi is Mr. Mkalipi. Is right to an extent. I mean, we know that a decision must be taken by the bargaining council, and there are certain thresholds to be complied with before you submit a request to the minister to extend an agreement. But what has happened here in this case, that in respect of the funds of the council, the minister can act upon the request of one party. And that gives the minister the power to extend agreements that only one party can ask, and that applies to the extension of funds of the council. And this is because a certain council is currently staffed. Because employers say, if you conduct yourself as a council in this manner, we're not going to give you money. What the minister says, and this, what the ministers can do through the current legislation, is to say one party can ask me and I can do it for a period. Now, we say that's wrong, and I think that's unconstitutional, but we can't just debate this for the whole evening. There are other issues, but I disagree with Mr. Mkalipi. I agree to a point. There's, broadly speaking, that's the case, that both parties agree and the constitution of the council comes into play. But in respect of extension of agreements, of funds agreements, the minister can act upon the request of one party.
Well, listen, you're not sitting in studio, our listeners, this evening, but I've got lawyers in front of me. I've got the Act. I've got the Labour Relations Act. I've got books in front of me. And I'm all of a sudden becoming a legal expert. Never thought I'd be that. I know something about markets, but not everything about law. Johan, you the lawyer, let's bring you into the conversation here. For people that don't understand all of this that we're talking about this evening, we're talking about bargaining councils, and we're talking about bargaining councils and their collective ability to be able to represent both an employer and employee at the end of the day. Do all industries have a bargaining council? I mean, what happens in a mine when a mine strikes? Is there a bargaining council somewhere involved in that?
Sure. So there are various bargaining councils. Bargaining councils are creatures of statute. They're created in terms of the Labour Relations Act. And if you go back to the fundamental thinking of the 1995 Labour Relations Act, the thinking here is to create a framework for collective bargaining, whereby the parties voluntarily opt in. Employers and trade unions opt in and say, we see each other as partners in this process, and we agree to bargain collectively on certain issues. And you can do that at plant level, you can do it at industry level, And that's where the bargaining councils come in. So the thinking of the LRA at the time was that we need to move our collective bargaining away from plant level and get it towards industry level so that we can manage this process collectively, so that we don't have a proliferation of trade unions, we don't have a proliferation of employers organizations, but we want to have large industry-wide platforms where parties can get together and negotiate on behalf of the transport industry, the mining industry, for instance. That never really materialized. We never had this large-scale buy-in and a move towards industry-wide bargaining, for various reasons. There was reluctance both from business side and from the trade union side, and mainly from the smaller players who feel that my voice is going to be drowned out. If I'm part of this whole bigger process here and I won't be able to determine my own way here, I can't regulate things that's peculiar and unique to my small little shop out there in Richards Bay, for instance. But personally, I don't think bargaining councils, I don't think collective agreements, I don't think bargaining council agreements or extension of the agreements per se is the cause of the difficulty that we have at the moment. I think fundamentally there's something wrong with the manner in which we bargain, both as business and as labor. I think at stages, and I advise clients on this thing, and I see a lot of it happening where there's parties negotiate in a very distributive or destructive manner. The typical negotiations, and Gerard will bear me out here, that you see at councils, is that the trade union will come in with a demand of 70%, the employer or employers organization will come in and say, listen, we may have to retrench if we have to implement a wage increase, and somewhere through a process of bargaining they end up with an agreement where there's a 6 or 7 or 10% increase. I don't think the manner in which we bargain necessarily assists us to get us where we want to be, where we have labor peace, we've got labor productivity, and there's definitely a need for us to look at it differently. And that's why, going back to the amendments, I'm buoyed by some of the changes that are being proposed. And I'm happy to discuss that for you, with you, in the next segment.
Well, what we're going to do is we're going to take a quick ad break, but when we come back, I want to talk a little bit about that exact subject that you've just opened up, Johan, which is the manner in which we negotiate. So again, my guest this evening is Thembinkosi Mkalipi, Chief Director at Labour Relations at the Department of Labour, Johan Boertes, who heads up Baker McKenzie's Employment Practice Group, and Gerard Papenfus, he's the Chief Executive at the National Employers Association of South Africa. We'll see you just after this. And now, for more entertainment, I'm joined this evening again by the panelists this evening. Thembinkosi Mkalipi, Chief Director, Labour Relations at the Department of Labour. Johan Boertes heads Baker McKenzie's Employment Practice Group. And Gerard Papenfus, who's Chief Executive of National Employers Association of South Africa. We're talking labour, we're talking labour relations, and we're talking more specifically around bargaining in South Africa. Thembinkosi, let me start with you, because Johan made an interesting point. The manner in which we negotiate in South Africa might be broken. Do you think that the legislative changes that you guys are proposing can fix that, or can go away in fixing this? Aren't we talking about the psyche of the South African that's broken?
That's why initially I indicated that the intention of this amendment, specifically the Code of Good Practice on collective bargaining, is intended in a way, whether it's going to succeed, that's something else time will tell, is intended to precisely change behavior of parties. Is intended to foster a different attitude in terms of collective bargaining. And that's what we're intending to do. And we hope that with the buy-in of the parties and the implementation of the Code of Good Practice on collective bargaining is going to do exactly what you're asking me.
I mean, let me be the voice on the outside of all of this. We've got a Labour Relations Act. We've got a minimum wage. Well, we're about to get a minimum wage. We've gone through all of this, but the unemployment rate runs at 25%. Are we not wasting our time? Gerard, let's start with you.
At the State of the Nation address, the new president talked about the process of deindustrialization, talk about red tape, and he said that he will give specific attention to this, and he will demand from the ministers, and he will see to it that they reduce red tape and that we engage in a process of industrialization. Now, I want to say to this, and Mr. Mkalipi is a person which I actually have a very soft spot for, although he won't believe me, because we've engaged on many places. But what is happening in terms of the extension of agreements, and I just want to focus on that point, is sabotaging the work of the president. Because this is the very reason why there's unemployment, and extension of agreements is a huge problem, because it is, if Johan says small business feel that they are disenfranchised, well, they must say though, because they are legislated, and the whole process is designed to disenfranchise them. Because here's an example: if you have in a country a business that's employing 1,000 people, and that company, and it is an oversimplified example, that company engage with their 1,000 workers and agree on a wage. That company can go to the minister and extend that agreement to 1,000 other companies, each employing one. So the one company has more voting power than 1,000 small companies, each employing one, because in extensions, as far as employers are concerned, the minister don't count the number of employers, they count the number of employees. So he can make an arrangement with the employees and put his 1,000 opponents, small businesses, out of the market. That's currently happening. This is what's happening. Now, the World Bank says it's wrong. The International Monetary Fund says it's wrong. Every economist in South Africa say it's wrong. The previous governor of the Reserve Bank, Mrs. Jill Marcus, says it's wrong. The current governor of the Reserve Bank say it's wrong. It is causing lots of joblessness right now. The number of people employed, for instance, in manufacturing, the steel industry, is now in the level where it was in 1980. Now, we're 14 years down the line. The number of people in South Africa then were 20 million, we're 57 million. We cannot employ because there are wage arrangements, Mark, that big business can afford and small business cannot. And I just want to say this. In the case of a big business, the ratio, and I just want to make the statement, then I'm off. The percentage of the impact of the wage as a percentage of turnover in a big business may be as low as 1%. In a small business might be as low as 50%. So big business, which is not affected by the high wage, make a deal and put small business out of business. This is crucial if we want to grow the economy. And if we want to help President Ramaphosa, we need to change this.
All right, well, Gerard, let me just, and Johan, please come in here, because this is a question that I've got for you. This that Gerard is talking about is really a breakdown between employers and the Department of Labour and the workings between those two entities. Shouldn't all companies be forced to belong to a collective bargaining process or to a bargaining type scenario where at that level potentially companies could be taken more seriously, taken their size? Because to ask the minister to take this into consideration and to distinguish between a small business and a large business and to try and make sense of all of this must be really, really hard. It's only the Department of Labour we're talking about. Why is legislation like that not potentially on the cards?
Yeah. So look, I hold a different view as to, whether the extension of collective agreements, is the devil's spawn. It is not a uniquely South African proposition. If you look at the EU, there are 5 countries in the EU who has legislation that allows for the extension, where extension of collective agreement takes place on a regular basis. My information is, Belgium, Finland, France, Luxembourg, Netherlands, Spain. These are jurisdictions where collective agreements are indeed extended on a regular basis. There are another 18 countries where the legislation allows for extension of collective agreement, but where it doesn't happen as a matter of course or regularly. And then there's only 7 countries in the EU where there's no legislation that allows for extension of collective bargaining agreements. So my view is, I don't think the extension of collective bargaining agreements, bargaining council agreements, or the institution of bargaining councils, is the cause of the breakdown and why we have the high rate of industrial action we have. Why is industrial action important? Why is the rate of industrial action important? Because that is where we see how the collective bargaining process breaks down. If parties can't reach agreement during collective bargaining, if the trade union and the employer, or the employers' organization and the trade union federation sit down and negotiate collectively, and that process comes to naught, the end result of that is industrial action. The trade union takes its members on strike. The employer locks the workers out. There's the industrial action. If you look at the high number of days lost due to industrial action in South Africa, that to me is an indicator that industrial action or that collective bargaining in South Africa is not working. I don't see the extension of collective agreements as the sole or the main cause or contributor to that. But what we do have, and Thembinkosi alluded to some of that, there are a couple of things that, if the amendments are implemented, really gives me hope that we can resolve this issue. And that includes, for instance, the strike ballot by members prior to a trade union going out on strike. The advisory arbitration process that will now be introduced, whereby before parties go out on strike, there'll be advisory arbitration by the CCMA, where you've got experts that will come in and sit and listen to the parties. So there are a number of these things that I do think can get this process back on track again.
Well, it's unfortunate because it's about to go 7 o'clock, and this subject we've only just scratched on. So, Gerard, I know that you've got your hand up, but unfortunately, the programming doesn't allow us to do this. So, we're going to have to wait. We're going to have to wait for the next session. Thembinkosi Mkalipi, thank you very much for joining us this evening. Johan, thank you for joining us. Gerard Papenfus, also, thanks goes out to you. Stay tuned for Glenn Lewington now and Classic Silver Screen up next on Classic 102.7. And thank you for listening to Classic Business with me, Cobie Legrange. I was standing in for Michael Avery, and he's back with you tomorrow with a special hour-long panel debate on the ECA Amendment Bill and the future of the ICCT sector. Good night.